Hello, my name is Nicole Horsley. This is a landmark case presentation to school board or staff members submitted in fulfillment of the related assignment in Administrative Leadership 805, Legislative and Legal Aspects of Special Education and Equity at the University of Wisconsin-Milwaukee. This presentation will focus on the landmark case Raphael Oberti versus the Board of Education of the Borough of Clementon School District. Some of the facts around the case. This is the case file named Oberti versus Board of Ed, submitted in 1992 under the United States District Court, New Jersey. The plaintiff in this case is Raphael Oberti. His parents and next friends, Carlos and Jean Oberti, as plaintiffs, versus the defendants, the Board of Education of the Borough of Clementon School District. Description of the issue or the challenge in this case. Raphael Oberti, the plaintiff, was a 7-year-old boy with Down syndrome. The lawsuit itself revolves around the obligation of his home school district in the Borough of Clementon, New Jersey, to provide for his education. The plaintiff's parents claim that Clementon's plan to educate the child in a segregated special education classroom outside of the school district instead of in a regular education classroom in their neighborhood school was adopted in violation of the IDEA, the Individuals with Disabilities Education Act, as well as Section 504 of the Rehabilitation Act. Facts of the case. There are 6 facts that I would like to point out for you. In this case, the plaintiff was evaluated and classified by the school district's Child Study Team, or the CST, as eligible to receive special education and related services. The CST also made consistent recommendations that the plaintiff be placed in a segregated, self-contained special education program outside of the school district. The plaintiff's parents refused that placement in a segregated program, and they continued to request that the plaintiff be placed in the least restrictive environment, a regular education classroom, in his home or neighborhood elementary school. Unable to come to an agreement, the plaintiff's parents requested a due process hearing. As a result, the plaintiff's parents and the school district agreed that the plaintiff would enter a special education class for children who were classified as multiply handicapped in the Winslow Township School District. Displeased with the services that were being provided at Winslow, in December of 1990, the plaintiff's parents requested a due process hearing for the second time. They were renewing their request for the plaintiff to be placed in a regular education classroom in his neighborhood school. A hearing was held in February of 1991 by an administrative law judge, and a decision that was favorable to the school district was rendered on March 15 of 1991. The CST continued to recommend that the plaintiff be placed in a segregated, self-contained special education program outside of the school district, and the plaintiff's parents continued to refuse this placement, thus escalating this case to the United States District Court. Procedural history. On March 15, 1991, an administrative law judge, the Honorable Joseph Lavery of the New Jersey Office of Administrative Law, ruled in favor of the defendant. The plaintiff's parents filed a lawsuit challenging that placement decision, and in August of 1992, the United States District Court of New Jersey reached a decision opposite to that which was reached in March of 1991 and ruled in favor of the plaintiff. The decision of the court stated that on August 17, 1992, the court ruled in favor of the plaintiff and against the defendant. Due to having found violations of both the IDEA and Section 504 of the Rehabilitation Act, the school district's 1990 to 1991 IEP and its placement recommendations for the 1991 to 1992 and 1992 to 1993 school years were not permitted. The court reached a decision opposite to that reached in March 15 of 1991, and it sent the parties back to the drawing board to design an appropriate IEP for the plaintiff, which was not allowed to recommend a self-contained special education placement for the 1992-1993 school year in accordance with the court decision. Additionally, the court authorized an award of all attorney's fees to the plaintiffs. The implications for educators and districts are found on two key components that are taken directly from the IDEA and Section 504 of the Rehabilitation Act. The IDEA states that special education means specially designed instruction at no cost to the parents to meet the unique needs of a child with a disability. Section 504 of the Rehabilitation Act requires that recipients provide appropriate educational services designed to meet the individual needs of students with disabilities to the same extent as the needs of students without disabilities. These two components imply that it is the obligation of the school and the district to strive for equity of educational opportunity and culturally responsive practices to promote each and every pupil's academic success and well-being. Schools and districts must demonstrate and document efforts to provide reasonable and appropriate structures, supports, and services for students with disabilities. Evidence and demonstration of this provision of reasonable and appropriate structures, supports, and services were missing in this case. The defendants were not able to provide adequate evidence of their attempts in this area. School districts and schools must also demonstrate and document an adequate approach to designing an appropriate IEP. I would offer that an appropriate IEP is also reflective of previously attempted supports and services that provided success for the student. In this case, the CST continued to develop an IEP that was not reflective of the supports and the services that were found to be useful to the child and family, and that allowed him to find success in supporting his growth through his educational career. Lastly, districts and schools must identify and document evidence to support the need for a segregated environment, which is based on significant impairment to the regular education learning environment if a placement of this nature is considered. Again, in this case, in this situation, the school district was unable to provide evidence that supported the need for a segregated child, for a segregated environment for this specific child. Thank you for your time and attention during this presentation.